Shall I introduce the next topic?
Yes.
Okay.
Yes, if you would.
So the next topic on our agenda is to receive a report from the Practice of Law Board on the proposed pilot project for entity regulation. So I have a couple things to share to sort of set up the conversation, but while I'm doing that, if Practice of Law Board Chair Leslie Ashley and Practice Law Board Member Craig Schenk would like to join us. So as a reminder, one of our priorities this year is to assess technology-related threats and opportunities. And this presentation is part of looking at our regulatory responsibilities. So I would invite you to be thinking about it through that lens. The board did vote last November to support the pilot project. And since then, we've really been working to put the flesh on those bones. I couldn't reach for a better metaphor than that. But we've been really trying to figure out the details of what that will look like in practice. And we've been working on sharing that information and gathering comment. A reminder that we did receive a number of very thoughtful comments about the proposal, which are in box. So if you haven't had a chance to look at those, please do. And with that, I will turn it over to Chair Ashley.
Thank you. My name is Leslie Ashley, and I'm the current Practice of Law Board Chair. One of the areas of the Supreme Court, as Tara said, is that they've tasked us with is innovation. And as a legal professional for the last 30 years in Eastern Washington, I've worked with marginalized and underserved populations. So I know firsthand the need for this project. And so it's with that intention that we present this update to you today. And I'm passing the mic to Mr. Craig Schenk.
Thank you, Leslie. Thank you, everybody. I'm happy to be here. We've had a baton pass at the Practice of Law Board, so I'm a new face to most of you. I know some of you are new here as well. This is a big topic, so I'd like to do an overview. I'm going to take about 16 minutes out of your busy agenda here to talk through some of it. First, a shout out and a thank you to Michael Cherry, Chair Emeritus of the Practice of Law Board, who did a fabulous job getting us this far and put a tremendous amount of work in over many years on this. Second, a personal thanks to Leslie for continuing to sponsor this work and continuing to push us forward. Now, as an icebreaker, I brought a show and tell piece. You can see. This is a Royal Model 10 double window typewriter. It's a beautiful machine, don't you think? I got it from my father. Dad got it from my grandfather. Granddad got it from my great-grandfather. I don't know where great-granddad got it. This particular Royal has typed out farm news, crop prices, insurance memos, boxes of beloved family correspondence, and many more boxes of legal memos when Dad worked late at home at night. In the 1960s, Santa wrote me notes on this typewriter. In the 1980s, I loved seeing it next to Dad's prized first computer, on which he learned Lotus 123 in his law practice to optimize real estate transactions and estate planning. He'd sometimes have both of them going at the same time, running the numbers on the computer and clacking away at the typewriter, explaining the numbers to his clients on the Royal. Dad was a lifelong inspiration to me. As a profession, he described, we need to bring out our continuing curiosity, our ongoing learning, and all the strongest tools to bear if we're going to deliver the best outcomes for our communities. There's another reason I brought the Royal. This antique machine joined our family just about the same time the state of Washington established its current structure and rules for the practice of law and the delivery of legal services. The depth of the Depression. It's the early 1930s, almost a century ago. Yeah, the machine still types. I love it with all my heart. Its feel, its music, its connections to my own history, and the tradition of the written word. But I wouldn't dream of using it in my solo law practice or in any other legal setting. The world has changed a lot in the last century, but the way we license and regulate legal services has not. And the Washington Supreme Court authorizes only individuals with a state bar card to own law firms, share legal fees, and practice law here. Think about the evolution that we're seeing in our daily lives. Uber, Amazon, for example, edging out taxis and retail. We're already seeing some of the same for legal services. The revolution to innovate and expand is already underway. And all of this is happening against a backdrop of a widening gap in the accessibility of legal services for consumers in Washington and across the nation. So the court faces a question then about what to do as a legal regulator. Nothing. Letting the emerging innovations in technology take the wheel and steer the market, maybe losing the ability to protect the consumers and potentially further widening the challenges with accessibility of legal services, leaving people behind. Or do something. Do something to begin to understand how to best protect consumers and regulate our profession in a rapidly changing world. Well, with insight and guidance from the court, the Practice of Law Board and Washington State Bar Association have developed a proposal that will start Washington down that second path to carefully study and collect data during a time-bound pilot process to test entity regulation. Yeah, to do something. Entity regulation broadly means shifting from allowing only licensed individuals to engage in the practice of law and to own law firms. Entities would be allowed to offer scope-limited legal services. That could look like businesses or nonprofits that want to use legal technology or non-attorney professionals to better serve clients, with licensed lawyers perhaps providing substantive legal input via training, expertise, system design, or availability for consultation. Testing at the entity level allows licensing and regulation to look holistically at the resources and services brought to bear on a representation, whether strictly legal or more complex mixes, taking into account innovations in both technology and business models. The intent of the proposed pilot is to learn more and make a transparent, data-driven decision about whether to implement any permanent regulatory reforms in a way that recognizes what's already happening. By the end of September, the Practice of Law Board and Washington State Bar Association will submit a draft order to the court on the implementation of the pilot. Research, experience, and similar pilots in other states show that there are great opportunities here. We can't out-lawyer the gap. We can't out-pro bono the gap in accessibility of legal services. There's just too much need. An expanded regulatory framework has the potential to support accessibility of legal services, as well as smart, effective business practices for lawyers. And expanding the regulatory framework also expands the capacity for oversight on the very top priority, consumer protection. Ultimately, the court needs more information to make data-driven, informed decisions about regulatory reform, to deal with the revolution that is already underway in a way that is good for all Washingtonians. The Practice of Law Board has been working on this proposal for years. The Washington State Bar Association, through the Board of Governors, has already agreed to support the concept of the pilot project and has been working closely with the Practice of Law Board to develop the draft order. So what are we looking for right now in this phase? Our hope with the publication and the comment period is to get feedback that will help us improve the draft order, get input that will help us improve and help with the implementation. If it's approved, the pilot will be the start of a multi-year process with many, many more opportunities for engagement, for feedback, especially as the court decides how to synthesize and act on the data gathered. Let's talk some more about the specifics of the order itself. First and foremost, the details won't be finalized unless and until we have an order from the court. The court has plenary power here. We have a draft order, and as noted in the draft order, each applicant will be required to propose a specific hypothesis related to reforming one or more regulatory rules about the entities practicing law, if applicable, other rules as well. They also need to propose a study to test the impact of that reform, and in particular on the results the applicant believes that they can achieve in delivering legal services, delivering access to legal services such as reach, cost, and quality. The pilot needs to run, and it's going to run long enough to collect 2 years of reporting by the entity most recently granted authority by the Supreme Court to practice in the pilot project. At the end of the pilot, the Practice of Law Board and the Washington State Bar Association will make specific data-driven recommendations to the court. The aim of the pilot is to protect the public while ensuring that the court has adequate data and information to make an informed decision. in the exercise of the plenary authority of over the practice of law. The specific monitoring and public protection included in the draft order include each applicant must identify a person authorized to practice law or another suitable person within the entity to act as a compliance officer who will be tasked with ensuring the entity's compliance with both the court's authorizing order and the applicable ethical rules. By its terms, this must be a person suitable to act as a compliance officer for the services that are approved. This means someone whose experience, capabilities, and professionalism are appropriate to be the compliance officer specific to the proposed service. The failure of an entity in the pilot to adhere to the laws of the state of Washington or the rules of professional conduct may well be detected through the data requirements of the pilot itself or through normal reporting channels. Both would give rise to a range of potential disciplinary actions, from narrowing or changing the scope of the authorization to withdrawing it, to ordinary consequences under consumer protection law, or even sanctions by the court under the individual order. So we've had this out. We've gotten some feedback. We have almost 30 items that have been submitted so far. I'd like to start by sharing some of that and share first a huge thank you to everyone who wrote in. We really appreciate it. The content is a gift, even the objections to the proposed pilot. Your input makes the work better, and we appreciate the effort you've put into it. The written comments have run about 2 to 1 in support of the current proposal, but we look at the substance of all of these. This is not meant as an election. We'll continue to review review comments that come in, and we're going to look at ways to use this input to improve both the draft order and the overall implementation, as well as the recommendations to the court. Some of the comments surfaced some themes that indicate maybe there's some misunderstandings in the proposed pilot, so I'd like to go ahead and address some of those. The proposal is a pilot and a methodology. It's not a new program. It's not a new regulation. And so the draft order is not written like a regulation. By design, it leaves plenty of room for options in what each applicant will choose to test. They're going to need to propose the framework. The pilot is not a way for disbarred or suspended practitioners to skirt ethical rules. The court and WSBA will actively screen and monitor each participant. Some of the concerns suggest an apprehension that unqualified individuals or robot lawyers will show up representing litigants. Neither is the intent of the pilot. The experience in Utah has shown that the likely applications will be for very specific scenarios that can be enabled further and more effectively with lawyers working closely with other professions or specific technologies. Here are some examples. Nutter, Brown & Coots is a personal injury firm using innovative technology as a front end and an intake tool, and an innovative business model to partner with technology investors and insurance carriers. They deliver services using licensed attorneys, non-attorney professionals, and technology, and they've been able to expand their practice with these tools. Raza Public Benefit Corp operates in both Utah and Arizona, and they focus on providing affordable flat fee services for criminal records clearance, a narrow task that can be done with expertise that isn't necessarily all lawyers all the time. With attorney involvement in the training, Raza serves clients who would otherwise not likely have access to these services. Holy Cross Ministries offers limited scope legal assistance as part of an overall health service offering, focused on legal issues in medical debt, healthcare, and public benefits. Holy Cross Ministries relies on community-based approaches and non-attorney providers, bilingual medical debt legal advocates with lawyer involvement in training and setup. Again, serving clients who would otherwise not likely have access to these services. The Timpanogos Legal Center runs a program in which trained, certified domestic victim advocates, not lawyers, assist victims of crimes like domestic violence, sexual assault, abuse, stalking, provide legal services to assist victims. And in particular, the victim advocates can draft legal documents to secure protective orders and stalking injunctions. They can provide legal advice pertaining to those protective orders and to stalking injunctions while they're helping the victims complete their paperwork and prepare for their hearing. Again, serving clients at a time of need who are otherwise may have nowhere to turn. This helps point out a key difference between lawyer licensing and the proposed pilot. Lawyers receive a broad general license to practice in pretty much any field of law they may choose. The proposed pilot anticipates specific, scope-limited permission that is tailored to the service offered and the capacity for oversight. This brings me to my own experience. The capabilities that an interdisciplinary team can create have the power to be far more on point and effective than a single discipline, whatever it is. And the capability of advanced technologies to help scale that work is already evident. Both of these tools are readily available to law departments for the largest companies in the state and in the world. Let's be clear, some of the largest entity-based permitted legal services on the planet are headquartered here in this state. And they're doing a great job. They're using all the staffing, technology, and business model innovations that we're seeking to test for consumers in Washington. They've learned and invested in what the New York Court of Appeals Chief Judge Jonathan Littman observed is that sometimes an expert non-lawyer is better than a lawyer non-expert. They are able to leverage all of this to get a lower unit cost and a higher quality bar for comprehensive tech-enabled interdisciplinary legal services than any consumer is likely to find for licensed legal services. That this disparity is not just permitted, but mandated by our rules of practice strikes me as a true injustice. And of course, this proposal is a pilot, not a rule change. This is not an invitation for private equity takeover of the legal services sector. The possibility that a private equity firm wants a piece of a time-limited, scope-limited pilot is approximately zero. And second, each participant is going to need to go through the application and court approval process and ongoing oversight for quality and for capacity. Finally, the likelihood that the world will end based on this seems low. We've talked about this as though it's the first time anyone's ever tried these things, but it's not. It's not an abstraction. It's not a novelty. Entity-based regulation is already a fact of life in England since 2011, in Australia, beginning in New South Wales in 2001. That was 23 years ago. And New Zealand, Wales, Arizona, all have firm laws on this. Remember, we already permit this inside large companies, even in ways housed inside large law firms. They're just hidden. Pilots in various forms are underway and under consideration in Utah, British Columbia, Saskatchewan, Ontario, Manitoba, Minnesota. I think I can stop there, but the list is growing. My point is that this isn't new and it isn't an abstraction. If we move forward with the pilot, I have high confidence based on evidence that the legal professionals of Washington will continue to deliver effective, competent services to their clients. The pilot will not be the demise of lawyers. And I have high confidence that the sun will rise the next day. The practice of law is an exceptionally diverse profession in so many ways. There are views across the spectrum on these issues. But change is going to come in some form. And I believe we should have a hand in how that change affects us, our profession, our communities. We've recognized that change takes getting used to. Points of view are likely to differ strongly. Building a successful pilot will take respect for what each person brings to the table and what each community values. I'm going to close with why I'm excited about this. We are very early in the process of understanding the convergence of a growing gap in access to legal services on one hand and disruptive new technologies on the other. How both will impact our practice and how we should govern our choices in the world are key decisions. The proposed pilot is an important milestone, but it's a beginning, not an end. This is going to be a long game. I hope I'm here for it. Back to the Royal typewriter. Before he died, my father learned about Washington's work on the pilot. He was 93 years old, well over 60 years into his practice of law. He said, "Good work," and then went to the Royal to bang out one of his favorite quotes from Franklin Delano Roosevelt. It is common sense to take a method and try it. If it fails, admit it frankly and try another. But above all, try something. I am humbled to be here and optimistic looking forward in this room full of legal professionals striving with a common goal: to adapt our profession for the long term so it reflects the best of who we are as professionals and as human beings. Our creativity, our curiosity, and our compassion. And that's what I'm most excited about here. We stand on the edge of trying something and willing to learn from it. Lawyering isn't just a learned profession. It needs to be a learning profession. So we end as we began, with huge thank you to all of you, including those on Zoom, for your time, your attention, and your contributions to the success of this pilot. I will look forward to the comments. Each one makes this better.
Thank you so much, Mr. Shank.